being highly emotional, even volatile, during a custody and placement dispute is normal. Why? Because you never signed up to be a part-time parent. You knew all along that you wanted to be a full-time parent, and now it's threatened. It's absolutely important to understand what goes into this process, and any mistakes or misconceptions need to be cleared up before it's too late. Tristan, I want to jump into a topic that I think a lot of people think about and want to know but don't really understand, okay? And that is parents' rights. Now, you and I as attorneys understand that parents' rights themselves kind of stop at the Constitution, which is we have biological rights to our children. But we practice in family court. And family court dives deeper into parents' rights, specifically into the right of custody and the right of placement, right? So when a court addresses custody and placement, they're really talking about parents' rights, aren't they?
Everyone has a biological mother and father here. So everyone has rights to be part of that child's upbringing, part of their rearage. So what we want to do is make people understand that when it comes to parents' rights, you're starting off on equal footing. Now, what can happen where you feel like your rights are being diminished? Well, your rights aren't really being diminished, but custody may have to be altered. So we talked about, custodial decisions with impasse authority, or one parent having sole custody over another parent's rights. When you talk about placement, a child spending more nights with mom versus dad, or dad versus mom, we're not diminishing your rights as a parent. What we're saying is, in the best interest of the minor child, what fulfills the needs that they need to flourish.
So it's not the rights that are jeopardized, it sounds like the allocation of those rights is what's being determined. Some party may have a greater share of placement or a greater share of custody.
Correct, but it doesn't diminish them to absolutely nothing unless you have no interest in your child whatsoever. If you have more placement time with one parent than the other time, again, it doesn't diminish your rights, but it's saying that what's in the best interest of the child is to spend more time at this house as opposed to that house.
So the court, if I'm saying this correctly and understanding this, the court starts at joint legal custody.
Correct.
So what are the alternatives?
So you can have sole custody, where you're going to make all of the decisions for the minor child, or you can have custody with impasse authority.
Would a court also look at the way that parents historically have been a part of that decision-making process?
They'll look at the historical perspective. They'll look at, what is the best interest factors. We've talked about the best interest factors previously. What falls into the school schedule? What falls into programming? What falls into having that schedule, having that routine? Where are their siblings going to school? They will look at those factors and they're going to say, okay, have we been able to meet all the criteria for this, and what is in the best interest of the child?
So let's shift to placement then. So it's my understanding that the courts of Wisconsin start at joint legal custody, right? Do they also start at equal placement?
The courts value that every child has a parent or parents, okay? That each child has a mom and a dad, that everyone needs that meaningful periods of placement with their child. So yes, if you think of placement almost like the scales of justice, which is how I describe it to my clients, you're going to start off from an equal position. Now, placement can be altered by weighing one side on the other side. What are the parents' schedules? Where are the children going to school? What is the proximity in location from each parent? What works, again, for the best interest of the child to make sure they still have meaningful periods of placement with each other?
You keep saying this term best interests, and it's, I think, a term that we hear often in our practice, but that really has significance. It's not just a part of a sentence. It really means something legally. What's the significance of that term, best interest?
So it's a statutory guidance or statutory factors that fall into what are the best interest factors for the minor child. There's actual case law that determines, there is law that determines what are the best interest factors. There are 16 best interest factors. The court will analyze those best interest factors when making a determination as to what needs to happen with the minor child, what best serves them in custody, what best serves them in placement.
I know that everyone could look up the statutes and read the statutes. Maybe lawyers enjoy reading statutes, and most people don't enjoy statutes. So could you do us a favor, and just in layman's terms, a couple of the best interest factors?
A couple of the best interest factors would be how the parents communicate. What is the historical perspective of the parents' relationship? Was domestic violence ever put into a factor? Is there alcohol? Is there substance abuse? Is there drug abuse? Those are a few of the factors that will guide the court as to what is in that best interest of the minor child.
So the court's going to look at each of the parties and whether they can be nice to each other or whether one is being a jerk to the other. Is that way to say it?
How you are able to communicate with the other parent, or the parent is able to communicate with you, weighs heavily on the court. If, for instance, you have a restraining order against the other party, well, that diminishes the ability for the two of you to communicate.
You know, we get the benefit of lawyers in many ways of being omniscient and having hindsight as our benefit. We can see all of the mistakes people make after they make them. Sometimes in real time, but most often we're looking back. So what are some of the mistakes people make that maybe they're not even aware of that dramatically affect the downstream outcome on custody and placement decisions?
Letting your emotions get the best of you. When you are dealing with a situation that involves a minor child, your sense of security or your fear is going to take over. And you are going to say things you don't mean to say. You are going to text things you don't want the judge to really be seeing. You're going to be doing the things that you wish you could take back. Things such as, I give up on custody. I don't want to deal with custody anymore. Or, you know what, just take the kid. I don't want the kid anymore. Those are the things that you're going to memorialize and wish that you wouldn't. The idea is that when you start getting into these increased moments of anger and fear, that you take a pause and you understand that what is your ultimate goal and what are you hoping to achieve? And whatever's about to come out of your mouth next, or whatever you're about to text next, is that really something you mean to say, and is that going to be in furtherance of your goal?
Probably worth discussing right now. So I'm old. You're not as old as me. I used to talk to people on the telephone. Seems like more people now aren't having conversations by phone. They're having conversations by text, by messenger, by all forms of social media. What's the impact from a lawyer's standpoint on that mode of communication?
Never, ever put anything into writing that you don't want a judge to see. That is the easiest thing that the standard rule that I wish as an attorney I could scream from the rooftops. Do not put anything in a Facebook message. Do not put anything in a text message. Do not put anything in an email that you would not want the court to look at. Because eventually, if custody, if placement become heightened, you're going to be surprised how much of that comes back in. Additionally, with the way that technology has improved, now you also need to be careful about the things that you say over the telephone because everything is recorded.
You know, the law of unintended consequences is something we see often, right? So I'll give you, for instance, I've seen plenty of circumstances where married couples, as a natural routine that they develop, is that one parent or the other, but not both of them, kind of take control of the kids' lives. So for instance, I've seen circumstances where one parent will defer to the other for homework or meetings with teachers. And why? Not because they're bad parents, but because they say, you know what, that parent's really more interested in school than I am. What's the risk?
So not so much when you're thinking about a family unit and you're thinking about in a day-to-day activity world, each parent might have divided up the household chores, may have divided up how one person's going to do schoolwork while the other person mows the lawn. You may divide up those ideas, but when the parties are becoming separated and when you're starting to develop those new homes, you need to understand that there's going to be a new normal. So although one parent may be great at homework and the other parent's horrible at homework, you just have to be prepared that if you're the parent that's not good with homework, you're going to start to be. And if you're not, you're going to get that child the help that they need to have to develop and to do well in school. You just have to be able to conceptualize that there's going to be a new normal and how you're going to adapt to that.